Hey, and thanks for tuning in to the Maryland Family Law Podcast, hosted by attorney Mike Mastrossi of MikeTheLawyer.com. If you're looking for practical guidance navigating difficult transitions with clarity and experience, then the conversation starts right now.
Your Honor, thank you for that kind introduction. I greatly appreciate it. Now it is my privilege to introduce my colleague and friend, Jamie Charette. Jamie has been a family law lawyer for approximately 20 years. She is also a court-appointed best interest attorney and a certified mediator. Jamie and I have met several years ago when we worked on cases on opposite sides. She was always pleasant, fair-minded, reasonable, but yet a very zealous advocate for her clients. I admired that, and since then we have become friends, and we also work on cases together in a co-counsel capacity. Her law office is primarily 75 to 80% of divorce and child custody situations, and she also does adoptions and estate planning. Jamie, did I get that right?
You did. Thanks for having me on the show, Mike.
My pleasure.
Excited to be here.
Yeah, absolutely. Today we decided to talk about a topic that a lot of lawyers will not discuss with their clients and potential clients, but lawyers often talk about it amongst themselves at gatherings, cocktail parties, out and about, etc. War stories, if you will, about other lawyers. And we call this discussing divorce lawyers, which encompasses custody situations as well. Called it the good, the bad, and the ugly. And Jamie's going to pretty much run the conversation as much as possible because I really liked what she had to say when we had this conversation, quote unquote, off the record a while back. We were talking about, we won't mention names about lawyers, but there are times when we as lawyers hear that another lawyer's on the other side and we just cringe because we know it's not going to be a pleasant experience.
Oh, yeah.
So with that, Jamie, talk a little bit about what you would call the good lawyers, and then we'll go from the progress or devolve, if you will, to the bad and then the downright ugly to work with.
Sure. So when I see certain names on paperwork, or I think of an attorney who I put in the good category, I always think of somebody who approaches from a perspective of trying to work out an amicable resolution if one can be had, because often that amicable resolution is pretty reflective of what the likely outcome in court is. And the question is just, will you take a very bumpy road to get there or a very smooth, efficient, cost-effective one? I think that a good attorney will always come to the table in a professional capacity, be responsive, be willing to collaborate, work together, provide informal documentation of things that might help get to that compromise place, rather than being overly litigious and aggressive right from the get-go. I just think it often does your client a disservice when you attempt to be litigious straight away rather than come at it from an amicable perspective first, because you can always be litigious. What you can't do is often get back to that amicable place once you've started to be overly aggressive.
It's a very good point. That's one of the things that I like about working with you. A lot of times when we're meeting with the client together, usually via Zoom, we'll assess the situation, and rather than starting off by filing either divorce complaint or filing a custody complaint, you generally opt for a letter that summarizes, hey, I represent your spouse, and I understand you guys are talking about separation, divorce. Here's what Joe proposes. Can't give you legal advice because I only represent his interests, but if you want to talk to me, you can. Or I suggest you get an attorney, have your attorney contact me, and we'll go from there. So it's a nice introductory, non-committal letter. And then the other bump up from that would be one that says, I've met with Joe, and here are the list of his things that he proposes and the issues he has, and go from there. But it's not, the letters that I see coming from you in that regard, they're not jumping out of the gate posturing, my client's going to get this and going to get that and get that. And we receive a lot of those letters from other lawyers where it's just from somebody was talking about Stripes the other night, the movie Stripes. It's settle down, Francis. Give it a break out of the gate. So I digress. But your comments on that, Jamie?
I think starting with a letter is such a great way to let the other party or attorney know what your position is. Like you said, in a non-committal way, you're making a proposal. You're not bound to take that position if it goes to litigation. But sometimes just seeing the proposal in black and white is often fairly calming for the other lawyer or the other party, and they realize their positions aren't really that far apart. I think when you have a conversation with someone, say over the phone, whether it's the attorney or the other party, they often hear one thing they don't like, jump on it, and the whole thing explodes. Whereas when you're reviewing a concise letter that actually states the position, they could digest that more easily. And they often see, wow, there's 15 things here, and we're actually in mostly the same place on 12 of these. So we've got 3 left. Let's talk about it and see if we can get all the way there. And I think that a lot of times lawyers will file for divorce first, and then they'll send a settlement proposal. And some of that goodwill has evaporated by getting the knock on the door from the sheriff, hi, I have paperwork for you. Whereas if you send the letter first, you don't lose a whole lot of time, but I think you can really get a jump on learning about the other party's position and letting them know what your perspective is on the outstanding issues.
And the other thing that doing it that way does is if you have the client that's retained you to write the letter and feel things out, so to speak, he or she doesn't need to come out of his or her pocket with, okay, we need a $5,000 retainer to start this and that. It could be a relatively modest retainer to get things going. Now, if the response you get back from the other lawyer when that person hires lawyers, go to hell, we want this and that, and we're never going to move from this position, then you can go back to your client and say, you might need to have a more sizable retainer because it's not looking well as far as the level of cooperation. So that's one aspect. And then on the good side is, let's suppose that letter results in a lawyer contacting you, and that lawyer shares the philosophy that this probably could work out, but emotions are high, etc. Maybe we do informal mediation. I like doing it with a retired judge. So you could say, let's go to mediation with a retired judge sooner rather than later, because once a court case is filed, you're going to be required to go to mediation anyway. But this way you get a jump on it. And if everybody's working cooperatively, collaboratively, you can take those people before a retired judge. And as there's something magical that happens, if you or I say to our client, this is what's going to happen, okay, maybe not, because their mother's father's next door neighbor's uncle had a different experience. You know what I mean? So you get that. But when you go to mediation with a retired judge and that judge says, look, I've been hearing these cases for 25 years, and let me tell you what's going to happen. People tend to listen, and sometimes people won't listen to anything, but your average reasonably intelligent person is going to take what that judge says to heart to some degree. And I think that's very helpful. But you can't do that lawyer to lawyer unless you guys are on the same page and are willing to take those kind of steps. And it's kind of like, it's almost like thinking outside of the box. If you just say, okay, I'm a lawyer, that means I file this. When I file that, I send out discovery. And I guess since we've used the word discovery a little bit, do you want to explain just briefly what the discovery is and how that can be part of overzealousness, if you will?
Sure. So discovery, I always think of, serves 2 different purposes. One is to collect information, and one common form of discovery is called interrogatories, where you ask questions that get answered under oath. And that can be helpful to gaining perspective on things like what custody schedule the other co-parent wants, what a typical day in their life looks like, a little bit about their finances. And then the other commonly used one is a request to produce documents. And again, that can be helpful to back up what they said in the interrogatories, and also to provide verification of what they state their assets are on various other filings. So my perspective is always that first thing I do when I hear another lawyer's involved is I call them before I'm sending out interrogatories and requests for production, before I'm really doing anything terribly formal. I always take the informal step. And I think a lot of people think that's a bit on the old school side, but I hope that persists amongst young attorneys coming out of law school too, because to me, it's a small world. Whatever county you're in, even if you're in a place like Baltimore City with hundreds and hundreds of lawyers, you're going to run into people again. And those relationships that you make, I think, really impact the reputation that you hold, the ability to get new business, the ability to get referrals from prior clients, the ability to get respect from judges when they see you in their courtroom. I always make a call first, and then I try to see, can we do anything informal that will move the case forward without doing too much formal discovery, which is expensive and cumbersome. But I certainly issue discovery in many cases because it is often necessary, but I don't jump straight to that. Whereas a lot of lawyers, they send it with their complaint. And to me, that is a one-size-fits-all kind of approach that is not going to really serve your client well, because you've spent hundreds of dollars drafting discovery you might not need.
It's funny because That's what I mentioned earlier, where some of the lawyers, it's like a system. I'm a lawyer, I do this, now I do this, now I do that. It's always funny because usually about once a year, you'll see interrogatories. Let's suppose the case is a divorce from a 25-year-old marriage, or 25-year marriage, no minor children at issue, and you got interrogatories that have been sent by the lawyer that ask you about the child visitation schedule. What do you think is in the minor child's best interest? It's like they don't even look at it. They just push a button, bill usually an incredible amount of money for the discovery process, and half of it doesn't even apply. So
Yeah,
it's
I think
always
a lot of people don't even read them before they send them out. They have a couple of different formulas and they just quickly send it off. I do try when I do issue discovery to narrowly tailor it to my specific case. A lot of my interrogatories say things like, please tell me all the facts that back up your allegations in paragraph 3 of your complaint, in which you state the minor children will be best in your primary care and custody. Because I really think if you're going to take the step to do it, you should make it worth your client's while and do it timely and make sure that it's narrowly tailored to the specifics of your client's case. Now, the two types of discovery that I think are almost always unnecessary in family law, but I see them from time to time, are requests for admissions and depositions. Now, a deposition is when you haul somebody into your office, hire a court reporter, spend thousands of dollars and many hours asking them the questions you're going to ask them at a trial anyway. And it's honestly, I almost feel like in family law, it's like a form of harassment because it's most appropriate in things like personal injury cases, medical malpractice cases, where you don't really know anything about the other party and you need to collect information. These people are married to one another or have a child together. They know a lot about each other. And I think it's almost always overzealous to do it. I just did one recently and I haven't done one in probably 5 years. And I thought it was a complete waste of time. And requests for admissions are the same. People, they like to do them because they're the only form of discovery that if not responded to in 30 days, there is like a massive penalty against you. So they think it's, I don't know, aggressive or it comes out of the gate strong. But you can only say admit or deny to it. You don't collect a whole lot of information from it. And it, honestly, I just think is wholly unnecessary. It's just charging your client hundreds of dollars for nothing.
I look at sometimes the overzealous discovery. It's almost what I call legal hide and seek. The goal is the person sending out all this an abundance of documents and questions. They're trying to get as much information as possible, and then the person who receives them is going to try to give them as little information as possible. So the whole process is a waste of time and to a lot of degree. There's certain things you need, but it doesn't have to be hidden within 30 long, burdensome questions that most of them don't apply. But that's a topic for another day, discovery and discovery abuses.
Yes. The other thing I notice overzealous lawyers doing with discovery is you have 30 days typically to respond. On day 31, I'll get a nasty letter. Your responses were due. It's day 31. I'm filing for sanctions. And it's okay.
Wow.
Calm down a little bit. Did you send me an email and ask if maybe I'm about to send them over to you now? It takes a lot of time to gather this stuff. Most lawyers do take more than 30 days, and certainly giving a little bit of leeway will go a long way to getting some goodwill when you need an extension on something.
It's almost one of my lighten up, Francis.
Yeah.
I can top that. I had one a couple years ago, and I honestly wish I could name names, but I won't. But the sad part is, like you said about reputation, I can tell you what, I probably told 10 or 15 lawyers about this person in this situation. And it started off with that letter that you're talking about. I got a letter day 29 saying that your interrogatories were overdue. So they're not even due yet. And I get the letter and I called and I voiced my displeasure to counsel. And that person said to me, "Oh, we like to be prepared here at our firm." I'm like, rather than admitting you made a mistake, you're gonna double down and say, "We like to be prepared." So the point is you've got the letter now. So that's how we started off our relationship. And it devolved into that person. I'm not being gender neutral. That person then actually told a bold-faced lie in a pleading that I called that person out on to the court. So that skips the ugly and skips the bad and goes right to the ugly. But before we do more ugly, let's chat a little bit about what we would characterize as bad. So what are the bad lawyers that we have to deal with? What do they do or how are they?
One of the things that I experience quite a bit is the attorney who's just utterly and completely unavailable when something time sensitive is happening. Trial's in a week, and you're calling and you're emailing and you're saying, hey, we need to file these filings in advance of trial. I need updated statements on a couple of things if we're going to have a hearing. And they won't call you back. They won't email you back. It's as if your communications are in the wind. And that can be really frustrating, because I understand everybody's busy and everybody has multiple matters going on, but it doesn't take more than 30 seconds to quickly send me an email. Hey, I'm in trial today. I'll give you a call tomorrow morning, rather than making me sit and wait all day wondering, I haven't heard anything. So that's one of the most frustrating things. And then, of course, there's the lawyers who they can't read the rules. The rules are very clear. You have certain deadlines, certain things that are required to be done in advance of various court proceedings, certain rules about when you have to file motions or when you have to file a joint statement or things like that. And they just refuse to adhere to those or refuse to review them beforehand. I had a case recently, that one I mentioned, I did a deposition in, where the rule says very clearly 10 days notice for the deposition, 30 days notice if you want documents. She sent me 11 days ahead a notice of deposition with a request for 3 pages worth of documents. So I wrote her back and said, I'll happily appear for this deposition because you noticed me with plenty of notice in accordance with the rules, but I will not be providing documents because you didn't adhere to the 30 days. So I think just that basic understanding of the rules is something, especially I see new lawyers, they just go off the cuff on things and don't think to review the rules before they file motions and file pleadings, which I think it can save you a lot of time and embarrassment if you just do that before you file things or reach out to counsel.
That's so true. It's funny because you mentioned about like reference to younger lawyers and how like old school. I remember my father being a lawyer, and his practice was personal injury. He didn't do family law. He was much smarter than I am. But I would hear him, and I learned so much through him with dealing with other lawyers. Basically, if something did not really prejudice your client, if you say, hey, can I have an extension? The old school people, they could care less when they got the interrogatories. In fact, the old time lawyers that were trial lawyers, they didn't even need interrogatories. They would do their work in the courtroom. You know what I mean? And so if you're doing interrogatories, it'd be like, okay, when do you need them? I don't care. Get them to me when you can. It was a totally different world. And you didn't, now back then, we were one of the last lawyers I know to have a fax machine. So, you couldn't confirm everything in email and all that, but you didn't have to. If I told you you can have an extension on answering your complaint until 60 days from now instead of 30 days, that was gold. It was your word. And it doesn't exist as much these days. And some of the younger lawyers, in my opinion, they have it's almost like a fear of picking up the phone. They operate by email, text message, and social media. But the old school phone, plus you get to build that relation. Hey, Jamie, I'm calling you on the Smith case, and I know the clients have had some back and forth, but I want you to know that I've talked to my client, try to put his head on straight, and can you ask your client about this and that? And that's how you make progress. Otherwise, when you get to the bad, a lot of times people will gravitate to a lawyer with their same personality. So if if they want to be the pit bull or the bulldog, they want to have that type of a lawyer. And you get the ugly lawyers, the way we're categorizing it, they'll say, my client says this and my client says that. And I point blank said this lawyer, so okay, that's wonderful, but who's the lawyer? You or your client here? I recognize what your client wants, but I'm not giving that client some advice that might be helpful. Not to tell you how to do your job, but what you're proposing is not helping. But that's that's a phone call.
Just to pick up on something you said just now about the pit bulls, I'm on a lot of Facebook listservs for lawyers, listservs for moms. I'm a mom to a toddler. And the number of people I see post something like, I'm looking for a pit bull lawyer to take my ex to task and do this and that, especially coming from people that have children together. I think you're doing yourself a wild disservice to absolutely look for someone who's going to tear the other person to shreds, because your child's going to see that, first of all, and it's going to damage whatever shred of positive co-parenting relationship could be left. When people ask me, they're like, okay, I'm looking for a pit bull. Can you help me? I say, let me give you a few names, because that's absolutely not how I operate. I will litigate when necessary, but I generally think it does not serve families to litigate these cases, because I can almost always predict the outcome. There are occasional outliers, but the laws and the case law, the statutes, they're pretty clear. You're not going to get, on a 30-year marriage, you're not going to get to keep your entire retirement account when the other party has none. That is not an outcome that I will promise anyone. That's not an outcome that's realistic. Most things are pretty clear how they're going to go for me. And it's just a question of making sure your client understands what is realistic, because I'm not a magician, I'm an attorney, and I can't make the laws different for you. I can't force the other person to agree to something that's not in their best interest. I just think the whole pit bull perspective is, I think for clients and the attorneys who subscribe to it, it's all around just bad.
I agree. So bad is a good word for that. Now let's go to the downright ugly.
Yeah, and that's a good segue, right? Because that pit bull mentality is it's just the idea that people have children in common or who've tried to build a life together, that they should end it on such a sour note, and that you would want to take on the personality of your very angry, emotional client, because it's perfectly reasonable to be angry and emotional during a divorce, which is why you hire a lawyer to zealously advocate for you from a reasonable perspective. And you want somebody who's going to, we often talk about client control. I don't like to tell clients, I'm controlling you, but client control for me is telling a client that is not a reasonable position to take. I'll give you an example. I have a case going right now where the parties agreed to sell their home. It was placed into a court order. The judge signed off on the court order. It is supposed to be listed as of now. The other party has now since changed her mind. And instead of the lawyer telling her, you're going to be in contempt of court because you're violating a court order, that is not a good look for you, and that is not going to be your friend for any of the other further proceedings. She's just saying, that's what my client wants. She doesn't want to do what the order says, so she's just not going to. And to me, that's poor client control, because your job is to tell your client, that is not something you should do. That is not my advice. They're hiring you for your advice and your expertise, not to parrot your anger and emotional perspective, because if they wanted that, they would just represent themselves. They want your sort of steady, calming demeanor, not for you to be jumping down the throat of the judge or the other lawyer.
And the ugly, they operate under the scorched earth theory. They do everything that they can to make your life miserable and make the lawyer's life miserable. And sometimes it's when you have a financial disparity, if one client who is difficult in his or her own right has the majority of the money, their philosophy is, let me just churn and burn and make this person run out of money, and then I can get my way. That happens a lot. The ugly side of it is too, when you have children's issues, like you were saying, a lot of lawyers, they could care less about what's best for the child. It's okay, my client wants 50-50 and will settle for nothing less. That might be the same client who's had the child by choice every other Saturday for the last 3 years. You know what I mean? So sometimes things are just unrealistic, but because my client says that's what they want, that's my position. Again, it goes back to who's the lawyer. But a lot of those lawyers help the parties or enable the parties, probably not the right word, because it's a more of a derogatory theme, is they foster the ill will for years to come. If you think that you don't get along now before you went to court, wait till you go to court and everybody brings out all the worst in each of you. You're a bad parent. You're a bad parent. You used to do drugs. You used to do that. And the reality is, I know everybody's raise your right hand. It's under oath. You swear to tell the truth, the whole truth, etc. But custody case, this is not a direct question to you, Jamie, but what would you do or not do for what you perceive as the complete well-being of your child? If the other parent truly was not an effective, good parent and had a lot of problems, would you perhaps tell a couple lies on the witness stand to help ensure that you might win your case and protect your child? I know you wouldn't because you're so honest, but there are a lot of people that would say or do whatever they need to do on the witness stand if they can get away with it, because it equates to, I need to get custody at all costs. So if I got to tell a couple lies, who cares? And anybody that said that doesn't happen is a fool. It's just the way it goes, in my humble opinion.
Yeah, I also think a lot of those people, they get up there, they say tons of bad stuff about the other party. Their lawyer counsels them that, yes, let's talk about what a horrible dad or mom the other parent is. And what that doesn't do is shine a light on why they're a fit and proper parent and why they should have custody of their child. just had a conversation with a client about this yesterday, and he said the other party smokes weed a lot and she drinks a lot. And I said, do you believe that she's fit and proper to have the children in her care? And he said, I think usually she's a good mom. I think she has some vices, but no, generally, I think she's a good mom. I said, then you're not going to be served by getting up there and talking about how awful she is. What you should do is get up there, talk about all your positive qualities, and then she's going to get up there, talk about all of her positive qualities. And the likely outcome in Maryland is some form of shared custody if it's feasible for the parties and they both express an interest and the proximity is able to foster that. We are definitely going away from all children should be with their moms. I see so much more 50-50 situations these days. And I see just as many stay-at-home dads or women who are out earning their husbands, or there's lots of kind of traction in the area of equality on both sides, I think. See so many more involved dads. And I think getting up there and talking about your positive qualities and what you bring to your child's life is so much more important than slandering the other person or talking about all their poor qualities. And I don't really understand why lawyers spend a lot of their trial, which is precious time because you don't have that much of it, to say all the bad things about the other parent.
That should be the highlight of this whole discussion. That is so important. And I think as a lawyer, when you have a client who is fixated on bashing the other parent, you've got to say, just like you said, but they've got to highlight their own positive parenting. But tell me 5 things about the other parent that are positive when it comes to parenting. You know what I mean? And even if it churns your stomach to have to say it, those things have got to come out from the witness stand, from your mouth, because first of all, when the judges look at these cases, whether the parties are married or not married, they cared enough for each other one time, even if it was only for a few minutes, to produce a child. And my professionalism has no bounds. But but the reality is there was some kind of intimate relationship, and there was some good things that you saw in this other person. And now you have a child together, and it's to get up there and just do a total bashing. It actually makes the basher look bad in some ways. It's like it's okay. Look, I do all these things great, and he or she, I know. How hard is it to say? I know the other parent. I know John or I know Jill loves our child, loves her to death, and you can see the affection when they're together. And I know he wants what's best for her, just like I do. And then, but then the but comes, but it's a subtle but. It's a more subtle, and it's not a bashing. It's just presented as a fact. But if you are, because you think about it, if you're a judge and you know this person's strictly going to bash the other parent, that also tends, in my opinion, to say, okay, this particular parent may not be the best one to have sole legal custody, because he or she has such a negative view of the other parent. They're not going to include that parent in decisions and things like that. It's not a far leap to think that, in my opinion.
Yeah, I think also those parents, the ones who have all of the negative things to say about the other parent, they fail to consider that barring some sort of extraordinary set of circumstances like incarceration, that parent's going to get time with the child. So if you sit up there and say they're the worst person ever, they have no feelings, they never did anything around the house, they don't care about our child, and then you get up there and say, I guess they should have every other weekend, or I guess they should have a partial custody split. It just doesn't track, and it doesn't land well because it makes it sound like you want your child to be with someone who you think is awful. Whereas if you say, look, he or she's a good dad or good mom, but I feel my child might be better placed with me a larger portion of the time for these reasons because I do X, Y, and Z, or I feel that I am more appropriate for this reason. I also think people fail to consider that your family's changing. You're either getting a divorce or you're going through a custody matter, and maybe that person will step up. I think the optimism is often missing from the perspective of the other parent. And then they often feel angry when the other parent does step up and starts to be a really good parent. They're like, he or she never did this before. And this is great for your child. This is an excellent change for your child. Okay, so dad never drove the child to school and now he does it on all his days. Fantastic. Now dad can interact with the teachers, meet the friends, meet the other parents. This is good news, not bad news. I understand it might be disappointing it took this to get there, but this is all positive. That's not a bad thing. But sometimes when you're going through this, people can put a bad slant on anything.
Oh, absolutely. I was thinking, when we talk about the ugly lawyer, I think the worst thing that you could say to a lawyer or to have a judge say it is, there's nicer ways to say it, basically you're a liar. So for a lawyer to have out and out lie about something to another lawyer or to the court, that's like a that's like a mortal sin. Your credibility is one of the most important things you have as an attorney. But there are attorneys that will, in a phone call, in an email, in a letter, will actually, I'll be kind and say grossly misrepresent things, intentionally grossly misrepresent. Is that a synonym sentence for lie? I don't know.
I think that works. I agree. Yeah, I think they will bend the facts in a way that is perhaps beyond.
Deceptive, so to speak.
Yeah. Yes.
Disingenuous. I love that word.
Yeah, I think, and that's another example of lawyers taking on kind of their client's personality instead of saying, that doesn't really make sense. Are you sure about this specific fact? Because I want to make sure we're right on the timeline, or I want to make sure we're right on that you had that money before the marriage or this or that. I don't think it serves your client when you just take what they say and run with it, because every lawyer is vastly familiar with the idea that there are three sides to every story. There's his side, her side, and the truth. And that's not to say everything my clients say is a lie, but I think it's slanted with their perspective. And it's your job to parse out from what they tell you what's accurate and what's not. Because they might say, I made every breakfast. And that's probably not true. There was probably a day that they did not make breakfast. I did every school drop off. I paid every bill. I think people tend to exaggerate a little bit when they take on a task, and then they just kind of run with that. And the lawyer should know that's not true. I tell clients when I'm prepping them for testimony, don't use words like always or never, because they infrequently apply.
I was just going to say that. Yeah, that's so true, because you just get tuned out when you say that.
I think so. And I think, yeah, judges really, I tell people it's okay not to know an answer when you're giving a response. If I say, Mike, what'd you have for breakfast this morning? And you say, I don't remember. That's okay. But don't say things like, I have no idea. You're just also giving the lawyer an opening to absolutely eviscerate you. I had my very first boss, I remember when he was teaching me how to draft questions, he said, now, if I say to a client, how much money do you earn annually? And they say, oh, I have no idea. You say, okay, so I'm going to write $1 million. That's correct? It's not $1 million. So you do have some idea. Could you give me an estimate? Maybe you don't get down to the dollar. That's okay. But yeah, part of, I think, prepping your client to testify, which is probably a topic for another podcast, is making sure that they're not exaggerating and that they're being accurate about their responses, because testifying is hard.
And that will lead us to the end of the ugly. So the ugly lawyer will teach his or her client how to do exactly the opposite of what you just said. Oh, we'll take a situation, and a lot of times you see the domestic violence cases and the protective orders where things are just exaggerated tenfold. Something may have happened, but it gets exaggerated for posturing position. So a lot of the lawyers that practice on the ugly side will take a small incident and just make it like it's the greatest, most dreadful thing that's ever happened. And again, taking on, I guess the theme of that is taking on the persona of their client, which is, you just can't do it. I know you've fired clients before, and I've fired clients before, just because our values aren't aligned. There's nothing wrong with that, but there's plenty of other lawyers out there that'll do whatever they need to do for the person. But I remember in law school, can't remember yesterday, but I remember from law school, there was a teacher who taught ethics, and he said, you've got to pass the Gillette test. And Gillette test was in the morning. I don't know he'd have a separate test for women, but the Gillette test was when you get up in the morning and shave and you're looking yourself in the mirror, are you happy with the way you're practicing law and what you're doing for your clients? So I don't know why I just thought of that, but it's true.
Yeah. No, and I think that goes to like your reputation as a good, bad, or ugly attorney. There are people, like we started the conversation today with, I see their name on a filing and I don't want to take this case. I don't want to have conversations with this person. I know how difficult they are. I know how much this is going to cost my client, and I just don't want to do it. And I think at the end of the day, I have to, as a practitioner, pick and choose the cases and the clients that I think will serve the reputation I want to have out in the community amongst my peers. I want to go to a bar event and not have everyone be like, oh, there's Jamie over there. Oh God, she's so awful. She's the worst. I want people to say, oh, I had a case with her. She was fair and reasonable, and we resolved it.
Before we tune out officially, Jamie, please give us your contact information so that people know how to get a hold of you.
Sure. So my office is in Catonsville. We're at 6328 Baltimore National Pike, Suite 200 in Catonsville, 228. I can always be reached on my cell phone at 443-274-1004 or by email, which is Jamie, Jaim like Mary, for law.com.
Thank you very much. I appreciate all your information. I think it was good content, and I hope that people get something out of it.
Yeah, thanks for having me.
Thank you. Take care. Bye.
Well, it looks like it's time for us to tune back out. Until next time, stay well and keep in touch with MikeTheLawyer.com.